Well, to chew over all this with me now is Martyn James from the complaints website Resolver. Martyn, I know you get lots and lots of complaints about boiler cover, and not just about this particular company.
Well, we do indeed, Julia. We get thousands upon thousands of complaints about boilers and home emergency issues. Obviously, as you'd expect, a lot of those are about engineers not turning up and being left cold. But terms and conditions can be such a huge thing, and some of them just aren't fair.
No, well, we had an instance, really, of that in that report, didn't we? I mean, we're always banging on about terms and conditions, and this is an example where it really pays off to know what it is that you're buying.
It really does, but it's worthwhile bearing in mind that just because an insurance company has put the clause in the contract, it doesn't mean it's fair. And if you don't feel you've been treated fairly, and let's face it, that clause in the film was pretty unfair from where I'm sitting, then you should absolutely make a complaint.
Well, we saw Helen concluding that actually in the end she didn't think boiler cover was worth it. And I'm wondering what you think. I mean, have you got boiler cover yourself?
I have got boiler cover. I've got boiler cover because my boiler hates me and I hate it. It doesn't respond to swearing or threats of violence or anything. So I've become quite adept at dealing with the boiler over the years. But it's not for everybody. So the average call out is around £400 for a boiler repair. Now, a lot of these policies can be £500, £600, £700 when you work out what you'll pay over the year. So if that's a false economy for you, if your boiler's relatively new, you might just want to put that money to one side. And as you said in the film, home insurance often has emergency cover too.
As she found out. Martyn, thank you very much indeed. Now it's a...
And indeed, we're hoping that our legal expert, Gary, here, sitting beside me in the sunshine, can advise us on something that quite a number of you have been contacting us about over the last few days. And that's a furniture store called Fab Sofas. They were set up in 2016 by the founder of DFS. And they've gone into administration, Gary, leaving an awful lot of people wondering what on earth that means for their orders, including Mary here. Now, Mary, tell me, you bought a new sofa. Tell me, why did you need a new one?
Well, I moved from a three-bedroomed house. And I went into sheltered accommodation, which is a one-bedroom flat. So I needed a small two-seater. So we thought, Lucy and me, we went round to the shops, didn't we? And then we went to Fab's, and I saw one I liked. So we paid cash, £348, I think it was altogether.
Yes.
And
why did you pay cash?
Because I'm partially sighted. And I have difficulty in reading numbers, so I can't use my little card unless I've got Lucy with me.
Yes.
So it's awkward.
No, so paid in cash...
It's easier for me, much easier.
But paid in cash to a company that's now gone into administration. Gary, what are the chances of her getting her money back or the sofa?
Well, all is not lost for customers of Fab. People who've paid with their credit card, of course, they can rely on the Section 75 of the Consumer Credit Act 1974. The credit card company is equally liable. So if Fab Sofas won't or can't pay, then the credit card company will refund. People that have used a debit card are in a similar position. They can ask their bank to use the payback procedure under the chargeback procedure under the debit card. Cash is a different situation. Cash is riskier in situations like this. In effect, you've paid cash for a contract to buy a sofa. You can't now enforce that contract, and you are someone who is now a creditor of the company, so you are at risk of only getting a fraction of your cash back.
Well, I know that an awful lot of people, one of the questions that they were asking us, and I'm sure Mary would want to know too, is how it is that a company that's about to go into administration should be taking money and taking orders in the first place. I mean, are they mis-selling there?
Well, I think the company would say that they were trying to sell the company as a viable going concern, so they had to keep trading to make it look like a viable concern for someone else to come along and buy and carry on with. Now, we do know that the people who've now taken over running the company to wind it up did find out that the company had acted very sensibly, and they have ring-fenced deposits that people did pay towards the end of the business cycle.
So it might well be that that money's been protected then.
That'd be nice.
Some people's money has been protected. I don't know if Mary's has, without looking at the paperwork, but some people have had their money protected.
But we've got to look into that, so that might be good news for you then, Mary.
Good news,
and it could also be good news, I think, for one of our other viewers, Kirsty, who emailed us to say that she ordered the furniture, sold the stuff that they already had. Because no furniture's come, she and the family are now sitting on the floor on cushions. But back in the studio, Gloria is not sitting on cushions. She's on a really nice, comfortable sofa.
Really expensive settee here, and I love Mary's. I hope she gets her money back. But great advice always from Gary. Now, when we say that we're going to keep an eye on the story, trust me, we really do. And here's an update on a situation we've been keeping track of since we first ran it last year. Back then, we were hoping lightning wouldn't strike twice, but unfortunately, for some drivers, it did. Last autumn, we reported for a second time on the DART charge, the online payment system introduced in 2014 to replace the old-style toll booths on the Dartford crossing on the outskirts of London. Now, it may have been a step forward for technology, but many motorists told us it was a frustrating and very confusing system that had left them with a fine even when they thought they'd paid their way. And the AA expressed concern that the same problems could arise with another online toll being rolled out 200 miles north, the Mersey Gateway.
We've seen the problems with the Dartford crossing. The same people are going to be managing the Mersey Gateway, and we want them to learn from their mistakes first time round and make sure it is a fantastic experience for everybody who uses the crossing.
Well, the Mersey Gateway opened to a great fanfare 8 months ago. But like the Dartford crossing, it also hit the headlines and, indeed, the Rip-Off Britain inbox for some of the wrong reasons. And the complaints have a very familiar ring.
Every day people saying, didn't know how to pay, and people across the bridge didn't even know it was a toll bridge.
In its first 4.5 months, the high-tech bridge has generated an estimated £3 million in fines. But in this neck of the woods, there's been a consumer fight back. And just last month, the Traffic Penalty Tribunal ruled that the £2 charge for the crossing was illegal due to a technicality when it was brought into law. And whilst that's now been remedied by the council, and the toll will continue, it's meant hundreds of penalty charges issued in the first few months of the crossing opening have been cancelled. Well, I'm quite sure that's a story we're going to hear plenty about in the future. For now, though, there's just enough time to ask our experts, Gary and Martyn, some of the questions that you've been kind enough to send in.
Gary, up for you on Facebook from Anor. He says he's got £300 credit with his energy company, lucky Anor, and he's been trying to get it back since November 2017. What can he do to speed things up?
Well, Anor, this is your money. You need to make a complaint in writing. You need to say that you're charging interest. 8% is the usual figure, and if they don't pay it back within 28 days, say you're going to go to the Energy Ombudsman.
Right. Martyn, one for you from Gemma. She wants to know about this. The three-piece suite her parents bought 2 years ago has faded badly. They think it's a manufacturing fault. Retailer disagrees, refusing to fix it. Anything they can do?
No problem. There should be a service agreement or a warranty that they can put a claim in on, but get this, there is a free ombudsman, the furniture ombudsman, that you can go to.
We're talking free today, it's
Yes,
marvellous.
we are.
And guess what? The three of us are free tomorrow as well. So that's where we'll leave it for today. Thanks very much for your company. And we're back at 9:15, so enjoy your day in the sun. From all of us, bye-bye.
Goodbye.
Bye.